Buenas tardes a todos. Pues el día de hoy, y gracias a la invitación de Douglas, voy a platicarles un poquito acerca de cómo se pueden adquirir propiedades mineras con certeza jurídica en México. So, what I want to talk about tonight is about the way to acquire safely and with legal certainty mining properties in Mexico. I've been working in this for the last 30 years, and I have seen many, many mistakes when we acquire the mining concessions or the properties, no? Because we are not only acquiring the mining concession, but we are acquiring certain liabilities, assets, rights, obligations, etc. The mining concession per se is the most relevant asset in the transactions, definitely. However, there is a bunch of things that we have to cover in the transactions, and the thing and the idea for me is to cover all aspects and not to get surprises thereafter. Because what we have passed in all these transactions is the assumption of liabilities that probably, if we have conducted a nice due diligence, we shouldn't be involved in. Therefore, there is this presentation goes a little bit in that regard, trying to get some ideas on how to conduct the transaction, correct? Tenemos un micrófono para poder caminar y esto por qué. Ok, gracias. ¿Sí? Bueno, ok. The first thing that we need to do when we are going to enter into a transaction is to identify what kind of transaction we're going to have. If it's going to be an assets transaction, which includes, of course, the mining concessions, or it's going to be a shares transaction. Because sometimes it is easier, it's funny, but it's easier to acquire a company rather than to acquire the mining concession and the assets. And the reason is that when you acquire assets, you are acquiring many other things and the mining concessions. All these things are assets, permits, water concessions, the social license, which is not assignable, but in somehow you inherit the possibility to conduct works in an area that the previous owners develop a nice relationship with communities. But if not, well, you're going to be in problems, right? So we have these two kind of transactions, typically in the mining industry, right? As I mentioned to you, the shares transaction can bring many benefits, but also it implies a bigger and deeper due diligence because you have to go over the company. Therefore, you have to see many other things than only the ownership of the company, the shares. But you have to see all taxation, you have to see all compliance regulations, etc. And what we cannot forget is that in a mining concessions transaction or asset transactions, we are acquiring not only the assets, we are acquiring also liabilities such as labor. Okay? This is important because sometimes I receive the call from a client telling me, I don't want to have any problem, so what I want to acquire is only the mining concession. And I said, well, the mining concession, if it was worked and previous owners had workers, a union was there, the union will not disappear. The union will go after the project, after the workers, after the benefits a company can bring, the new company can bring to the union. So, not necessarily acquiring only the assets will isolate the risks on acquiring a mining project, the whole mining project, as if it was a running company, okay? This is very important to consider. Okay. The first thing we have to do when we are entering into a transaction, especially companies that are listed in the different stock exchanges in the world, is to have an NDA, a non-disclosure agreement. Because immediately after we start receiving information and delivering information to the other party can use it for press releases or just simply to get information that may be used in the future. So we have to be very, very careful. That will give us the possibility, the possibility to disclose everything and to request information, documents, etc. Because the information, when you are entering into a transaction, is not only the information that the acquirer will receive from seller. The seller will ask for many information about the acquirer. No? It will request probably financial statements from the acquirer to see if he can really face a transaction like that. Okay? So that's why it is important not only to be protected as a seller or acquirer. Both of the parties are very much interested in the information each of the other. Okay. First thing we're going to have is an LOI. And honestly speaking, 90% of the transactions that I've been involved in my life arrived to my desk with an LOI already signed. And unfortunately, many LOIs do not contemplate many things that we will be then trying to renegotiate. And that is a big problem. Because when I read the LOI, it does not contemplate many, many things needed to be included in that. Because the LOI indicates the transaction. So are the most important terms and conditions to be included in the definitive agreement. Okay? So if you come back with, for example, the seller and say, hey, I did not contemplate this and this and this and this and this and this, the seller will say, my friend, I'm very sorry. This is the way we're going to do the transaction if you want. If you don't want, I'm sorry. Okay? And it happens. It happens. And you will see something very important. For example, for instance, ¿le puedes cambiar acá? The description of the asset or the company, depending on the kind of transaction, if it is a mining concessions transaction or is a company transaction. Detailed information about the mining concessions, definitely. No? If we don't, I have experiences in the past at which they say, well, this mining project. So the mining project is covered by how many mining concessions? And what is the area covered by the mining concessions? You may not know. You can be thinking about a mining project which is comprised by a bunch of mining concessions.
but the seller could consider that it's only the core what he is selling to you, and not the rest of the mining concessions. So we have to be very careful on accurately state what is the purpose of the transaction. The objective of the transaction is to acquire these mining concessions. And these mining concessions have an area, attach a map. Because I have seen in the past that you enter into an LOI and you take 30 to 60 days to conduct the due diligence, and during that period, suddenly there is a division on the mining concessions. So you stated in the LOI one mining concession with one title, right? So let's call it La Soledad, title number 1. Perfect. I'm acquiring La Soledad, title number 1. But the owner of the mining concession divided the property in 2. And then you have La Nueva, number 1, and La Soledad, number 1. And when you do the transaction, you receive La Soledad, number 1, and not the other part of the mining concession. I have seen it. I'm sorry to say it, but I have seen it. And we have gone even to Canadian courts, try to fix the thing. No? Because we put the guy who sold the property, it was an offer to put it into the board of the Canadian company. So we use the possibility to demand the guy because he was at the board of the Canadian company. Otherwise, in Mexico, it was fine. He sold one property, he identified the property, but there was no map, there was no measure of the mining concession there. Nobody knew what happened. And you received something that you wanted to receive, but it's not in full. It's just part of what you wanted to acquire. That's what I am talking about, detailed information about the mining concession. An inventory of the most significant assets. The plant, no? And also, I have received plants which are half of what we saw first. So you can take pictures, you can sign pictures, you can do many things to protect. Okay? Disclosure of the liens of the property, no, over the property, if there are or not. Better to know if there are some which you can acquire a property with liens, is not a problem. The thing is that, are you assuming that responsibility, or you will lower the price, etc. Many things to consider. We have to state for how long we will take a term to conduct a due diligence. There, no, is important. To me, when conducting a due diligence and having a satisfactory due diligence conducted, it may represent 40 to 60% of the success of the transaction for the acquirer, and lots of certainty for the seller. Okay? This is very important. And that's why we recommend to have a due diligence. And take enough time to do it. And let us work. You're going to do your due diligence on all technical things, geology, metallurgy, and many other things. But let us work. We need to do things also. Okay? So we need enough time and the cooperation of the seller. And the only way to push the seller to give us the information and documents is through you, the acquirer, because you are the one with the money. The other wants your money. So we need cooperation from the acquirer to push the seller to give us the information and documents necessary to conduct a due diligence, a good due diligence. All right? In addition to all the documents we will need to see, and we conduct the due diligence with those documents and also information that we get from the authority, from the Mines Bureau and from the Public Register of Mines when they open the door to do it. Because we have to make sure about if usually the mining concessions are not in full compliance with payments of mining rights. No, we all have experienced that because it represents money, and probably the money is on field and not on just payments to the government to keep the mining concessions. Very important. It's the most important asset, so we have to take care of that. So what we need is to review how much they owe, but also if the Mines Bureau has sent the notice of cancellation of the mining concession. Okay? We have received many canceled mining concessions. And then we have to work with the seller. When I'm representing the acquirer or the buyer, I have to work with the seller to try to recover the mining concessions. And sometimes it is impossible. You know it. No? So it is very important to conduct that due diligence on the information that we can get from the Mines Bureau or from the Public Registry of Mines. In addition to the other part, which probably Luigi told you, guys, about all the reviews that you have to do for environment, water, etc. No? Because it may imply the closure of a mining project, and you're acquiring something that you cannot be able to use, to explore or to exploit. In addition to that, I recommend to conduct the other part of the due diligence, which is to know more about where the mining project is located, making sure that the municipality, the state government, communities, neighbors are friendly with the mining industry. If they are not, you may face lots of problems. So it's much better to conduct activities where you have the support from the government, from the communities, neighbors, the owners of the lands, ejidos, etc., than to be in an area where they don't like the mining industry. No, that's what happens. You can have all permits, but the social license, and without that, you are not going to do anything in that project. You will be experiencing blockades, and then the union will join the people living near the area, because they joining efforts, they will block you even more aggressively. So you have to be very careful with that part. Typically, a term to conduct a due diligence is 30 to 60 days. Sometimes it's larger. I have experienced 6 months due diligence in a very big project with lots, and that was an assets acquisition. We didn't enter into the companies. We did everything on an assets, mining concessions, etc. And it took us like 6 months to conduct that. It was a big project that had many issues. So we needed more and more and more information to make sure that those issues were able to be fixed. Okay? And to be able to give the possible buyer all the risk that it was acquiring jointly with the project, not only good things. Okay. So after completing the due diligence, no, and all the technical things that you guys do, you take a decision. And taking a decision is not only to see the good things, but also the bad things about the project, no? And see how you're gonna fix or try to make regular situations that the project doesn't have, no? Typically, when you talk to a mining concessionary, an individual that has been working the property forever, his dad did it, he's done it, etc., and they go to a new area of the mining project, which is not the real original mining project. They believe that they can use everything they had in the past in the old project. Permits or not permits. Remember that if there are some dispositions about when you started a project and that project didn't have permits because there were no laws ruling about how to conduct exploration or exploitation. There was no MIA, there was no other kind of permits. So you can continue to do that. But if there is a new area, definitely you need new permits, you need permits. And when you acquire a project from an individual mining concessionary, typically this project is not in full compliance with law. And there is where we do the diagnosis about the legal condition of the project and propose to the possible buyer how to fix it, or we have to be very honest and say, impossible to fix it. All these things, it's going to be impossible to talk to the authority, or how to restore the relation with the community. No? Sometimes you need 2 or 3 generations to get confidence from them to conduct mining activities. I have seen projects that they stopped operations 20, 25 years ago because they had a problem with the community. And when the new player, the new mining concessionary comes and try to restart operations, they don't get, unfortunately, they don't get the consent from the neighbors or the communities. So that's something very important to take in consideration, that part. And that's not a written thing. This is merely goodwill. It's merely goodwill. Okay? Okay. How to structure a deal, the transaction? The first thing to consider is going back to the LOI. Be sure about what you are arranging, because it's going to be a complete different story to have a transaction as is where is than a transaction that the seller remains liable for things that happen in the past in the property, or actions or inactions he did in the property. This is very important. So don't forget to go back to the LOI and state in the LOI what kind of transaction is this in terms of liabilities, obligations, responsibilities. Okay? This is absolutely fundamental. Again, when you talk with the owner, and the owner, he will be agreeing to many things, but when the agreement comes, he will deny having accepted many things. Do it in writing, please, in the LOI. When I do acquisitions through companies, I even include and schedule to the LOI with all wages of the people working there. Because when I acquired a company, sometimes the general manager that is probably the owner of the project was receiving $10,000 a month. And when I received the company, he's receiving $25,000 a month. Imagine that. So that's why it is important when a company transaction, you need to have the accountants looking at the financial statements, all the tax documents, etc. And having a representation in the same agreement stating that, for example, wages haven't been changed for the last 6 months. Because that's, to me, a material representation. It could impact, no? You develop a model of business in the mining property, and then you have double in wages, double with suppliers, double with contractors, because the main contractor of the project is the same owner of the mining concession. So be very careful with these things. Okay, so on the reps and warranties, sometimes I do 30 pages on reps and warranties and 3 pages of the rest of the agreement. Because it's the most important part. The seller must represent to the acquirer what is he selling and what are the conditions of the assets and mining concessions he's selling. Okay? It's a big list. I'm putting here only some. I have another document here that if it is possible at the end, I will put here a list of reps and warranties that we should include in an agreement, making sure that we know what we are acquiring and making sure that all those things that have been represented, in case that the seller is representing only nice things about the property, he should indemnify the buyer for lying in those reps, because he's misrepresenting things that lead the buyer to buy the property. And that's why we have to include a bunch. And it's easy to say, we don't have MIA, we've been working like this. And then the buyer will take the decision, because he probably already talked to the lawyer to see what are the consequences of all works that were performed or conducted without this permit. And probably it's not a big deal. The problem is that you are assuming that everything is correct and you will be facing problems. Okay, so absence of liens and royalties. There is another typical thing that you discover after you acquire a mining property, that it existed a royalty payable to a third party, and you never knew about that. So a rep in that regard is also material. Compliance with environmental, labor, and regulatory requirements. No? I was telling you, even if you are buying only the asset, it is likely that operations were closed, for example, 6 months ago or a year ago, and the union can come back and say, hey, I'm here, and this is the agreement we put in place for this property, so we need to comply with this agreement. No? The limitation of responsibility that I mentioned to you on if it is a transaction as is where is, or there are the seller is retaining responsibilities. No? Also, in the agreement, for the legal certainty of the seller, we have to include an space in the agreement stating clearly that from now on, all activities, actions or inactions in the property will be responsibility of the buyer. Okay? This is important, and I believe that it is fair to include that in an agreement, and to release the seller of the activities of the new owner of the property. This is very important. Nowadays, when we're going to enter into a transaction assignment, we need to get an authorization from the Mines Bureau. I mean, it says the law enacted May 23, stating that the assignment of properties, mining properties, the mining concessions, require previous authorization from the Mines Bureau, from the Ministry of Economy. However, as we all know, the rules to the mining law haven't been published and therefore not enacted. So we cannot apply something that it doesn't exist. What we are doing is we are not asking for permission to assign a mining concession, but we are continue to file those for registration. Okay? Now, the law only considers two kinds of agreements to be registered at the Public Register of Mines. The most important is the assignment over the mining concessions, and secondly are the liens over the mining concessions. So when you're going to have a financing for the property and you grant all the assets, including mining concessions in warranty, you pledge the mining concessions in favor, let's say, a foreign investment fund or a foreign bank or a Mexican bank. They are not miners. Remember that in order to have a mining concession, to be able to be a mining concessionary, you have to be, as a company, registered at the Public Register of Mines, the company. Individuals, no. Only Mexican individuals can hold mining concessions, no foreign individuals. Mexican companies, including Mexican companies with 100% foreign investment. But these companies must be registered at the Public Register of Mines, okay, in order to be able to own mining rights. When you have a credit and then you grant the mining concessions in warranty, a pledge to Scotiabank Canada, in accordance to the law, you have to request, in accordance to the law, you can register those warranties in the Public Register of Mines. You can. The problem is that it takes many months to get registration, and usually the creditors give you only 15 days to complete registration, and that is impossible. We have explained all the banks, BMO, Scotia, you name it, and they still don't understand. After 40 or 50 financings I have participated recently, they still ask me to have completed registration of the warranty in 15 days. So I have to extend every 14 days, knock the door, and get a waiver, extend the term, etc., etc., etc. It's part of what I do on a monthly basis in the law firm, because the Mines Bureau is, the Public Register of Mines is not giving us many answers. No? Okay. The other agreements that we are used to do, and the typical or probably the most used agreement, is the option and exploration agreement, right? option and exploration agreement. Typically, we are buying a mining property that we don't know, and probably there is no information about previous exploration. Hopefully all the properties would have the 43-101, but it's expensive. Not many people wants to do it because Mexicans, we don't need to do it because it's private companies, right? But when you buy a property, you need to have time to conduct certain works that may identify if underground is what you are looking for. And that's why we have these option agreements. By the way, a long time ago, I was the first Mexican lawyer that registered an option agreement in Mexico. Before, we had other kind of agreements, but I was very pushed by the Canadian lawyers asking me to have option agreements. And I said, no, well, but in Mexico, we don't have that kind of agreement. Please, we need it. Otherwise, we will not be able to raise the money at the stock exchange. So then I explained at the Mines Bureau and to the registrar what was this option agreement about, and then we were able to register the option agreements. Today, the law only foresees registration of assignment agreements and the warranties that I mentioned to you over the mining concessions. But for the rest of the agreements, you have to give notice to the public registry. If you have an option agreement, it's valid. You can do it. Option with exploration, exploitation agreement is valid. It's perfectly valid. But you have to give notice to the public register of mines about the existence of these agreements, okay? The bad thing, and probably you have never heard the following, is the important thing to have an agreement registered before the public register of mines is, number one, the same law states that. So the Mines Bureau will acknowledge that there is a new owner or someone has rights over the mining concessions when the agreement is registered. Never before that. Never before that. Second thing, and probably for lawyers is the most important, is that the publicity that the public registers give in Mexico, the publicity. It is that if I sell to him a mining concession, or we execute an option agreement over a mining concession, for him to conduct exploration and thereafter to take a decision to buy the mining concession, he will be protected if the agreement is registered at the public register of mines. And he will be protected from all of you that want my project too. If the agreement is registered and I sell the property to Mark, to John Mark, what will happen is that, well, number one, I'm committing fraud, right? But since the agreement is registered at the public registry of mines, he will not be considered as a good faith acquirer. Okay? Therefore, that transaction that we did is null and void. But if we didn't file the agreement for registration and it was not registered, and Jean-Marc comes to me and I sell the property, he's a good faith acquirer. That acquisition is valid. And then I have to come back and just pay back what I got from him, because he was a good faith acquirer. You see why is so important the public registries in Mexico? What I've been doing for creditors, for example, to register those warranties that I mentioned before in order to comply with something, I'm using the movable assets registry, and then I register there all these warranties. And then I comply with the demand from the creditors to have the warranty register in a public registry. Okay, so it is something that you can do. Use that registry, the movable assets registry, okay, and register the warranties. Okay. Now, the problem we have when we will not be registering exploitation agreements or option agreements is the following. 5? Okay. Is the following. Is that the Mines Bureau will not consider an optionee, the optioner, sorry, not consider it as someone with rights over the mining concessions. Therefore, who's going to comply with the obligations over the mining concessions, the main obligations? Semi-annual mining fees, payment, work assessment reports, and production reports. Only the registered holder, or the one who is registered with the rights over the mining concessions. Now that we are not going to register the agreements, we don't know how the Mines Bureau will react at having a third party, which is not registered, complying with the obligations. It's going to be a huge problem for everyone. Huge problem. Okay. Well, this summary is so short. I'm very sorry. It's I have another presentation here in front of me, which is like 20 pages or such, and it's only text. No, it's impossible to go over everything. Well, an agreement also shall contain, of course, the part of the agreements reached. For example, price, very important, how the price is going to be paid. If it's a mixed consideration, typically here, everyone will know that, with cash and shares from the parent company, which parent company is listed in the TSX, etc. Right? And also, a very important part of the agreement, very, very important part of the agreement will be the indemnities, the part of the indemnifications, right? And it will very much depend on the kind of agreement. If it is as is where is transaction, or if is a retained liabilities by the seller. Okay? Misrepresentations. And also, importantly, misrepresentations and what is representing the seller, not necessarily what is representing the seller, should be assumed by the buyer. But you have to state it in the agreement. If not, let me tell you, typically from sellers, and I represent lots of sellers, I'm not against sellers. No. But typically is, well, as I open the door for you to conduct a 30, 60, 90 days due diligence, you saw everything. It's your responsibility. No, come on. That's not my responsibility. Since I represented all these things, it's your responsibility. No, except that the agreement says that. That's why we have to be very careful the way we draft agreements, in order not to be, for me, the challenge in drafting an agreement is not be confusing. I want the seller to read and understand exactly what the buyer is reading and understanding. And guess what? 60% of the cases is not the case. 60% of the cases is we are reading this and the other is reading a different thing. So that's very important, no? To be able to read exactly the same. I'm sorry. Well, this is me. Thank you very much. It's lots of more things to tell you. Unfortunately, we don't have all day long to do it. But happy to be here once again with you guys. And if you have some questions, we can go now.